Oh, I don't do that. I need to change it in because it's the jury's copy. Miss Run Things. Yes. She didn't want to identify herself. I don't understand why my view is like this. Okay. On the record in the matter of the people of the city of Lansing versus Kayla Walker in file number 22-03464, the council appearance.
That's Staples for the city of Lansing. Assistant Public Defender John Lee on behalf of Kayla Walker.
Back in courtroom 4. I know it's a little tighter, but at least they adjusted the temperature. So it's a lot more bearable.
Amanda Well.
This is the continuation of jury trial that began yesterday. Before we closed yesterday, there was an issue of a motion to admit the city's exhibit number 3, I believe.
Correct, Your Honor.
The argument of the defense was that there was an issue with the chain of command. I took some time to research the duty of the prosecutor and laying out the foundation for the chain of command. And based on that information, I am going to deny admission. You need to lay some further foundation because I re-listened to the testimony and the questions that was laid out. And all the city ever asked Mr. Hackenberg, or the officer asking Mr. Hackenberg, was it his duty to transport blood kits? He said yes. He took the blood kits to from the quartermaster to an MSP. And that doesn't sufficiently lay out or establish a chain of evidence. So you have to trace through competent evidence exactly where the chemical sample was at all times, even how it was stored. It was in the quartermaster. We don't know what temperature it was stored at. Was it put in a refrigerator? When was it checked into the quartermaster? Who was the quartermaster on duty at that time? What time was it checked out? How long did it take him to get to take it into MSP? And who did he hand it over to? And specifically, when he took those out of the quartermaster, they should have been labeled. How do we know that the quartermasters, because that's all he said, or the blood kits included hers? And so that is the additional testimony that would need to be laid out. You obviously have the right to recall, and I'll let you do that under your rebuttal, because I don't know where Hackenberg is right at this point.
Your Honor, we have the evidence technician who actually authored the report of the samples that Hackenberg took that day, that he testified to having taken on May 19th, and he is here and ready to testify. So we can do that now or as a rebuttal witness.
Okay, no, if you have witnesses, I would like you to do your witnesses before them. I just didn't know if you had any here now.
Can I present this to Ms. Nash to be
Yes,
potentially
please.
marked?
And the interim, let me see if this is in the way. And I recognize that you have this person, but you still probably have to recall Hackenberg because he was the one who transported it. You have to trace through at each point where those blood samples were, because you have to show that they weren't tampered with and that they were properly cared for the entire time. So there can't be a break in there in order to get that incident. Where's Miss Run Things?
I'm sorry, I don't know why that popped up there, but Letitia Jackson.
Okay, Miss, that's your client, correct? Or is she, okay. She's having an attorney? Doesn't have one in here. Is anybody handling pre-trials for you today?
I have Frederick Greer and Gavin Boundaries in the hallway.
No,
No, I want to know.
you want to know if anyone's handling your cases today.
Well, because
No,
you're in a
I'm
trial,
sorry, Your Honor, no.
because you can't do both. Okay, well then we'll reset them all.
Okay, thank you.
Miss Jackson,
Yes, ma'am.
we got We're in the middle of a jury trial that is carried over from yesterday, so we're gonna have to get you a new date because your attorney is the defense on this trial, okay?
Okay, no problem.
We'll get you the date now.
Okay, thank you.
May 14th at 8:30.
May 14th at 8:30, okay, ma'am?
Okay, thank you.
You're welcome.
Bye-bye.
Mr. Von Bruce was not in custody? I thought he told me that Mr. Von Bruce was outside. He's in custody,
Oh,
correct?
you know, I think I said the wrong name.
Okay.
Yeah. Well, Greer is outside. But it's not outside. James Minor is outside.
Greer is outside. Does he have, do we have witnesses on Greer? Where's the
Sorry.
prosecutor?
We'll go get him.
Let me go off the record of this one. Simmons is in custody and Morgan is in custody. Morgan, I can't put it. Oh, it's already adjourned. They want to request. Okay. On the record in the matter, the people of the state of Michigan versus Frederick Greer, file number 23-03610, council appearance.
Assistant Prosecutor Phaedra Trosky on behalf of the people.
Mr. Public Defender John Lee on behalf of James Greer.
Mr. Greer is present.
Yes, he is.
Okay, did you have witnesses here?
This case was actually joined with Mr. Drew's felony case that was bound over, I believe, last week. And so I wasn't sure of the process. I guess I'd probably just file an all for this case since the charges were already joined.
Oh, okay, so that is correct. We need an ollie on this one. Record on that matter. Morgan is in custody. Somebody wanted to, who's on Morgan?
I have Rashida Morgan.
There's a request to adjourn.
Yes, there is.
Okay, you're gonna waive her appearance because we're not gonna bring her up for this.
Yes, I will wait for the future.
On the record in the matter of the people of the state of Michigan versus Rashida Morgan, 24-00240, council appearance.
Good morning, Your Honor. Case marked Marion appearing on behalf of the people under Michigan Court Rule number 8.120.
Assistant Public Defender John Lee appearing on behalf of Rashida Morgan.
Today was the date that was scheduled for a final actually it was scheduled for a jury trial, but there's a request to reset this due to unnecessary witness being unavailable. Is that correct?
Yes, Your Honor, that is my understanding.
How much time do we need to reset this?
Prosecutor's witness.
Whatever works best for the court, but I think maybe 2 weeks to a month would probably be.
Okay. July 2nd at 8 a.m. They're letting us call in juries still? That's the week of 4th of July. They'll probably wait till the last minute and tell us we can't call in a jury.
July 9th.
So that may get, no, we'll keep it there because they didn't tell us. We'll keep it there. If they bump it, then it'll have to get changed.
Thank you.
No problem. Off the record on that matter. Brittany Padilla, present.
Yes, sir.
On the record in the matter, the people of the state of Michigan versus Brittany Padilla, file number 24-00407, council appearance.
Good morning, Your Honor. Case marked Marion appearing on behalf of the people.
Jacob Rowley on behalf of Ms. Cole. Sorry, Ms. Padilla.
What was the date and time that was scheduled for a final pre-trial? Do you have witnesses here?
No, Your Honor, at this time, the necessary victim or complaining victim has failed to appear. People would be moving to dismiss.
Motion to dismiss dismiss is granted without prejudice. They have the right to reissue the charge against you within the statutory time frame if the necessary witness appears and is ready to proceed, okay?
Yes, Your Honor, thank you.
Well, I'm talking to the defendant right now.
All right.
Do you have any questions about that? Okay, we'll get you a copy of your dismissal in just a moment, okay? You already reset Wallace?
No.
Okay, on the record in the matter of the people of the state of Michigan versus Jack Wallace, file number 21-01061. Appearance for the record.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
And Assistant Public Defender Scott Nichol on behalf of Mr. Wallace.
Oh, today was the date that was scheduled for a jury trial. I think this one we got an email about. Yeah. Okay, and then your client alleges he has COVID.
Yes, he called me yesterday morning to inform me over the weekend he tested both Saturday and Sunday. He tested positive for COVID.
I don't know if people still got COVID. No, just fine.
And so he did let me know he wasn't going to be able to attend.
It does appear he's been present for all of the previous court dates. I have no reason to doubt that he's trying to skirt his trial date. Plus, it was gonna get bumped anyways, because we're already in the middle of a trial.
Understand that.
So we will reset this matter. June 25th at 8 a.m. June 25th, 8 a.m. Okay, sounds good. Any additional matters for the record?
No, Your Honor.
Thank you, you're all set. Alrighty. Ms. Donnelly, are you representing Gregory Brown Varian?
I am, Your Honor.
Russell Dawson is present. Do you have counsel? Why is your counsel not? Well, it's a sentencing.
Sorry.
Separate sentencing.
His probation officer did that. It's for the.
I thought I sentenced you, but I thought it was delayed sentencing. Well, so it's supposed to be separate sentencing, which means the attorney is technically supposed to be here. You can waive your attorney's present though. On the record in the matter of the people of the state of Michigan versus Russell Dawson, a file number is 23-02744. The state putting their appearance on the record.
Morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Okay, sir, state your name for the record.
Russell Dawson.
Okay, Mr. Dawson, you was previously represented by private counsel. And you were before the court back in December. I put you on a term of probation, but I sentenced you under a 771.1 delayed sentencing. And I indicated that if you were successful on a term of probation, meaning you had no issues, that the court that no conviction would enter against you. See anything from the probation officer? So I don't know why they would just set it and not say anything. Nonetheless, I'll take that to mean that there was no issues. I've not seen any violations from the time that you were placed on term of supervision by the court. This was a unique circumstance. I'm sure you learn a lot from that encounter, and hopefully moving forward, you won't find yourself in any similar situations, correct? I'll be consistent with the judgment, which is sentence under 771.1, no conviction shall enter against you. Good luck to you, sir.
Thank you, Your Honor. Have a great day.
Same to you. On the record in the matter of the people of the state of Michigan versus Gregory Brown variant and file number 23-03656, council appearance.
Morning, Your Honor. Case marked Aaron, appearing on behalf of the
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Gregory Brown Berry, who is appearing in by video.
Are you driving?
Yeah, I'm pulling in now. I just dropped my daughter off.
All right, well, we'll reset your matter.
No, I'm in here.
I don't have to advise your clients anymore that they don't drive in court. May 14th at 10 a.m. Off the record in that matter. Let's see. There's more than already correct. Martinez is in custody and Saunders is in custody. Anybody else waiting for a state case? Coleman?
Yeah, but now.
What time? Oh, Brite Coleman, I see it. On the record in the matter of the people of the state of Michigan versus Brite Lee Coleman, file number 24-00469, appearance for the record.
morning, Your Honor. Case marked Aaron, appearing on behalf of the people.
David Brown, on behalf of Mr. Coleman.
Okay, today was the date set for final pre-trial. Do we have witnesses here?
Your Honor, one of the witnesses that was required to be here, Sequoia Goodman, is not present, so we would be moving to dismiss that charge.
Carolyn Black is present.
Carolyn Black is not, but I believe her appearance was waived.
Waived by whom?
Your Honor, I have my notes that at the last court date, which is the 53 hearing, she was present and you noted that she would not be required to appear at the final pre-trial.
Okay, I don't have that note, but thank you for that. Okay. So the people are moving to dismiss against Sequoia Goodman.
Yes, sir.
So that will be dismissed as to Ms. Black, we need to set that for trial.
Yes.
It looks like it's set May 14th at 8 a.m.
Which count is supported?
One second.
Sequoia's count 2. Any additional matters for the record?
Nothing. Thank you.
No, Your Honor. Thank you.
Thank you. You're all set. For the state. That's all we have.
I do have Mr. James Minor here as well, Your Honor.
But what are we doing with Mr. Minor?
I don't think that. I think
Final
we were
pre-trial
gonna
and
set
jury
up a
trial?
final pre-trial.
We'll get you a final pre-trial jury trial date. Who do you have, Mr. Raleigh?
Jennifer Finn.
On the record in the matter of the people of the state of Michigan versus Jennifer Finn, 23-02304, appearance, please.
Good morning, Your Honor. Case marked Aaron, appearing on behalf of the people.
Jacob Riley on behalf of Ms. Finn.
How are you, Ms. Finn?
How are you?
I'm well, thank you. This is a assault and battery. Was there an offer on this?
Yes, Your Honor. The offer that was extended was to plead guilty as charged with a caliber agreement to no project.
There's no offer, you continuing to trial.
Yes, Your Honor.
Okay, we'll set it for final pre-trial and jury trial. We'll get you a copy of that date. Do you have any questions for the court?
No, no.
Okay, you can have a seat. We'll get you a copy in just a moment. Minor, what's the final pre-trial? For James Minor.
Oh, I don't know. Just trying to do hers.
Oh, okay, what's hers?
Hers is June 18th at 8.
Jury trial. July,
July 9th.
right. We do understand, sure. Okay. 19, July 9. What's your name, sir? Okay, we just set yours for final pretrial and the jury trial. We'll get you your date in just a moment, okay?
Okay.
Are you ready, Mr. Reed, for us to bring the jury back in?
Yep.
Okay, sounds good. Okay, back on the record in the matter of the people of the city of Lansing versus Kayla Walker. Any other matters before we bring the jury back?
Not at this point, Your Honor.
Just ask for 5 minutes, Your Honor, maybe I could run to the bathroom quickly and back.
Yeah, all the way downstairs?
I'll ask the guards if they can let me into one of them.
Okay, yes, please tell them that you're in the middle of the trial. You can have a seat. Oh, we need Paige or somebody to sign a nollie for that lady, is that? Oh, yeah. Sumner didn't appear. I'm bench warning Sumner. Are we ready to bring the jury in? Ms. Julie, we can bring the jury in?
Yes, Your Honor.
Okay.
more rapidly.
Rise.
Okay, very good. You can be seated. Everyone for returning to court today promptly for day 2 of the. We'll have more witnesses that they intend to call. You can call your next witness.
Your Honor, the people call George Olds.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. State your first and last name and spell both.
First name George, last name Olds, Georgeolds.
And have you testified in court before?
I have not.
Okay, so a couple rules. If there is a yes or no question, you have to say yes or no. You can't do head nods, head shakes, or mm-hms, we do have a couple fans going. We have these glass partitions in certain areas, but she's my court recorder. She has to take down everything that's being stated here. So we need your voice to be loud and clear, which it's been. If there's an objection from any of the attorneys, you would stop speaking immediately, even if it's midway through your answer. I'll make a ruling on that objection, and then I'll tell you if you can give that response or not, okay?
Okay.
You can proceed.
Good morning, Mr. Olds. Can you tell me what you do for a living?
I'm an evidence technician for the Lansing Police Department.
How long have you had that position?
6 years.
And what does being an evidence technician entail?
We archive evidence, essentially. The road will bring in or tag in evidence, and I'll retrieve it from the lockers, and then we place it in the according spot, depending on the crime type or the dimensions of the item. We also then check items out to detectives for court cases or lab work.
Mr. Olds, I'm going to show you what's marked as People's Proposed Exhibit 4. Do you recognize what this is?
I do.
What is it?
It's a receipt that's generated after a transaction. It's generated by our evidence tracking software file on Q. It's kind of a database, but it's also a tool that monitors or shows the chain of custody of evidence.
And is that a record kept in the ordinary course of business?
Yes.
And is it created contemporaneously with the time that that evidence is checked out?
This receipt was created by a transaction on the date that's printed.
Okay. And is your name on that sheet anywhere?
Yes.
Your Honor, the people would move to admit the property evidence transfer receipt.
Any objection to People's 4?
No objection.
People's 4 is admitted.
I'm also going to show you, Mr. Olds, what's already been admitted as Plaintiff's Exhibit 2. On this document, you'll note that there's a case number. Do you see that number?
Incident number, yes.
Yes. And is that number reflected on what has been admitted as People's Exhibit 4?
They correspond, yes.
Okay, and what does that indicate to you?
When an incident occurs, a number is assigned to that incident. An LPD number is usually 10 digits. So this number was assigned for this incident here. And any evidence generated from that incident will also have that number.
Okay. And so it would be fair to say that this highlighted number is the kit that this sheet came from.
Biological sample,
Yes.
and that's correlated to this number, yes.
Okay. So I want to go through with you, what is the process for getting these samples? This is published to the juries.
You have to ask permission to publish to the jury, though, and I need to see it because I need some more questions fleshed out on this. Do you have another copy?
Yes.
You can give the witness, because I need to
Sure.
question the witness something. One second. And were you still questioning him on that? Or are you done? Questioning?
On the fact that these two numbers correlate? Or
Oh, I
in
didn't know if you had
general,
more questions on that document,
on this one, or on this document?
the one
Which
that
Hunter?
people's for.
Yeah.
You have more questions on it?
We do,
Okay,
yeah.
so we don't publish until all you're done with all the questions.
Correct.
But I'm sorry, Your Honor. I think that he was publishing an already previously admitted document, not number.
Yeah, I was just giving the jury back exhibit 2, which was already published to them
Okay.
yesterday.
I thought you showed him people's proposed for.
I did, and People's proposed 2, which had already
Okay.
been entered. in
Got it. So
evidence.
you have people's two, which
Correct.
you questioned him about what the identifying number was on there?
Correct.
Okay. And what, I suppose, is his knowledge of that document? That's because that was admitted to another witness.
It's a document that's already in evidence, Your Honor.
I understand that, but you're questioning him about it, so I want to know.
I'm not questioning him about the document. I'm just questioning him that these two numbers are the same.
Okay, that was what I was trying to figure out, because I don't have a copy. Typically,
Correct.
when you do that, the judge should have a copy, so I know what's going on. That's why I asked if you had another copy.
Sure. I have the one to publish to the jury I can hand to you, or
See, that's all I want to know. You don't have another
Okay.
copy. He's just clarifying that. That's fine.
that they're the corresponding numbers.
Thank you.
Mr. Olds, can you go through the process of what happens when this transfer takes place?
Sure. The court officer at the time was Officer Hackenberg. Comes to the quartermaster unit, which is on the 4th floor of LPD, requesting the blood kits. And they kind of accumulate. It's not a regular. Some court officers come once a week. I don't remember what Randy's or Officer Hackenberg's routine was, but we had a collection of them. According to this receipt, we had, well, it seems regular, and they take them to the lab. He'll approach the counter. It's a secure room. I go retrieve them from the refrigerator. It's a lab scientific refrigerator. It's secure with a lock. I unlock it, retrieve the blood kits. The blood kits are segregated from other cold evidence. Each type of evidence has its own shelf. The blood kits for these types of cases is kept in a specific spot. I retrieve them, bring them to the counter. We go through them. I have a barcode scanner, kind of like a gun, and like what you find at Miner or Target. I scan the barcode on each blood kit. It's got a LPD created barcode. It has a case number, the type of crime, the date it was received. I scan all those barcodes. The computer recognizes those scans, and he signs for them physically. And over to him.
And that's what took place on May 19th of 2021.
Correct.
No further questions for the witness, Your Honor.
Thank you. Cross-examination.
Thank you. Thank you, sir, for taking time. So your role then at the lab is to facilitate the transfer of evidence from the freezer to whoever's picking it up or in need of it?
It's one of my functions. It's not a lab. I'm the holder of evidence
Okay.
for the department.
And then the primary identifier on all the kits is a name, is a number, is a barcode. Which one is it?
There's a couple different agencies involved. There's a standardized kit. I believe it's from Michigan State Police. I'm not positive on that. It's a cardboard box that is made available to the hospital. They might fill out some handwritten information on the box. I believe the box has its own identifying number from the state. Not again positive of that, but we have our system. An officer tags it in. They enter the information into File IQ, which is our software. Does not have a suspect's name. It has case number, item number, a subset of the case number, the type of charge, the date it was received. That's all entered in the computer. They generate a label by pressing print. Or that label is a barcode representation of that item number.
Gotcha. So it's the barcodes, that's the primary identifier going forward from that point.
From our perspective, yes.
No further question.
I have a question. When are you scanning kits in and out, or do you just take them out and hand them over?
But it is scanned out.
Okay. Who scans? You scan or someone else scans?
I scan. I'm one of 3 people in the unit. But
Okay. In this particular instance, the people exhibit 4, I'm not sure what that is yet, but there's anything on there that indicates that you scanned that kit when you transferred it to the officer?
when we set up a transaction, so that's a function in the computer, the officer at the counter, I'm telling the computer, I want to do a checkout.
Right.
The computer says, okay, what are you checking out? I scan the items that I'm checking out. I identify the person I'm scanning them out to. And since I'm logged in, it has me stamped as the user.
And all that is on that receipt, correct?
And so this receipt shows that I scanned out 12 items on May 19th. Officer Hackenberg.
Okay, thank you. Redirect.
No redirect at this time, Your Honor. We would ask that the exhibit be published to the jury.
Any questions from the jury for this witness? Mr. Needs. Okay, and so what you are take part after the suspect has been, or the defendant has been tested, correct? I mean, not before the test.
Correct.
You're taking the blood results after they've been to the hospital, the blood's been drawn, it's transported back to the quartermaster.
Depending on the hours of the day, the officer's got this cardboard box with the kit in it, the blood draw. They submit it to our evidence room, which is a secure room on the 4th floor, or there's one at the ops center. It has a refrigerator, has lockers for evidence. This type of evidence requires refrigeration. They place it in the refrigerator. I come in the morning and retrieve the items from the lockers and from the fridge.
Okay.
And then I put it into our secure fridge. And then it sits until somebody requests it.
Okay, in this particular incident, this particular kit, were you present when that kit came in to the quartermaster?
One of the 3 of us would have had some scan history, taking it from the evidence room.
I'm asking, were you present?
I don't know what day it came in.
Okay, maybe you could question about when it came in and who, if he had personal knowledge of that.
Your Honor, I think that information would have to be recalled from possibly Officer Stevens, who checked the box in and when and what day he checked that box in. I think the witness has stated that he has no personal knowledge of when it was actually put in the fridge, just that he then transferred it to the evidence fridge.
Well, I just asked, was he present when it came in? He said one of the three of us, so that wasn't clear as of whether or not he was there or not, or if he just doesn't know if he was there.
The kid could come in at any time, 24 hours a day. I'm in the office from 7 a.m. to 3, but even then, the officer wouldn't submit right to our counter. They would submit to the evidence room. So depending on when that occurred, I could have been in the office.
But you're speaking in your general sense, and I understand the process. I am asking a specific question because I am trying to identify a chain of custody for this particular kid and not in general. Do you know if you were this person who took the kid and put it in the refrigerator?
I do not know.
Okay.
I have the means. We do have.
That's what I know you probably have the means to figure that out. That's why I'm asking if you know, or, and if not, maybe they can refresh you. But we need to identify if he was the one who took custody, because we have to tie that.
Correct, Your Honor. I think we would need a brief recess to get that information.
No problem. And maybe you can recall him later if that's what you need to do. Okay.
That would be fine, Your Honor.
Any other questions for this witness? Okay, you can be excused for now. Oh, there was another question?
Sure, question.
Oh. You can publish. I never responded. Okay, what is the margin of error in this process of handling the kit? So it says, how often in your experience have you seen evidence either mislabeled or mishandled?
A wrong label on a piece of evidence in total can happen, has happened. On blood kits, I have not known specifically of a mistake. It's possible.
That's both mishandled and mislabeled.
In terms of mishandled, I don't know. I've not known a blood kit to get lost, dropped or mistreated, or left out in a temperature situation where it's a very fluid process.
Any other questions from the jury? And I'll wait for them. He can be excused. Thank you.
Your Honor, we would reserve the right to recall this witness.
Absolutely. Any other witnesses at this time for the people?
Just the rebuttal witness of Hackenberg at this point, Your Honor.
Okay, but you're gonna call him right now, or did you want to call him?
No, we would need to call him later.
Okay, sounds good. Is the defense gonna call witnesses now, or did you need to make any motion at this point?
Your Honor, we asked our court to
Yeah,
consider.
well, I'm asking you a specific question. If you're gonna go on a motion, you don't do it in front of the jury. So
Don't do it in front of the jury?
I'm asking you, are you going to call witnesses now, or did you want to make a motion? If you want to make a motion, I need to release the jury.
We'd like to make a motion.
Okay, all rise for the jury.
Rise for the jury.
Okay, you can be seated. Call your witness, Mr. Lee.
The defense calls Kayla Walker.
You get to the step, you'll raise your right hand. Again, do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. And you've heard the rules because you were here when we gave them. We need yeses and nos, no head nods and shakes, or mm-hms and uh-huhs. We need your voice loud and clear because there's a fan running here. She's got to take down everything being stated, and there's another fan running here, and I need to be able to hear everything you're saying, okay?
Yes.
So you can use your outside voice. You see how loudly I'm talking?
Yes.
And you're not talking that loud?
Yes.
Thank you. Okay, you can proceed.
Ms. Walker, thank you for being here. This incident is fairly dated. How old were you when all this went down?
24,
And how old are you now?
29.
29, okay, so would you say that things in your life have changed quite a bit since then?
Yes.
At that time, you were dating a young man named Moses Linguia, correct?
Yes.
Okay, and how did you feel about Moses?
Love Moses.
Okay, so you cared about Moses deeply. Okay. Did Moses have anything going on in his personal life that you were aware of that made you feel protective of him?
Yes, I knew he was on federal parole.
Okay, and is that why he was wearing the tether?
Yes.
Okay, and so what was your concern for Moses on the day of the incident?
He told me that if he was caught driving, he would be in trouble and sent back to prison.
So you didn't want Moses to go back to prison?
Correct.
Because if Moses goes back to prison, you don't get to see him anymore.
Correct.
Gotcha. You also had another concern, I think. I'm gonna explore it a little bit with you. Whose car was it?
My mom.
Okay, and did your mom have any rules about who was allowed to drive that car?
Yes, I was to be the only driver.
You were to be the only driver. And did you follow the rules that day?
I did not.
No, you let Moses drive, right?
Correct.
What made you let Moses drive?
Drunk.
Okay, and so did you trust him to be able to get you where you were going?
I did.
Okay, that didn't work out.
No.
Okay. I also noticed in the video that you and Officer Pung kind of weren't really vibing with each other. Is that an accurate description?
Correct.
Okay. You felt somewhat, how did you feel about Officer Pung?
I didn't feel like I was listened to. I felt just like I was guilty without any cause. At that time, nobody actually seen what happened.
You understood why she would want to follow up, but you did make a couple statements to the effect that you were driving.
Correct. Yes.
And what made you say that?
I was trying to protect Moses.
You regret having made the statements you made to protect Moses that day?
Yes.
Go back in time, would you do it different? No further questions.
I'll cross-examine.
So Ms. Walker, you just testified that the statements that you made to Officer Pung were lies, correct?
Correct.
So these are timestamps to Officer Pung's video that's already been substantially gone over and is admitted into evidence. So it's 6:15 on her video. when you said that you were dropping people off and that you were driving, and when, so someone said you were driving and you said yes, that was a lie, correct?
Yeah.
Okay, at 9:18, when you said the people who smashed me drove off, you were lying again, correct?
Objection, Your Honor. That's not, that doesn't go to her being the driver or not being the driver. Whether they do both.
You said the objection is that that doesn't go to her being the driver.
Yeah, that's a total-
The statement was the people who smashed me drove off.
Correct.
You're asking her, was she lying? I think you do need to clarify as to because the people who hit the may have drove off, and she may not have been lying about that. So
Okay.
she might want to be clear, or might have a struggle answering that. Maybe you can
I
clarify.
can just
that.
discard that question, Your Honor, that's fine. At 11:03 on that video, when you said I was driving 45, you were lying, correct?
Correct.
At 11:19, when someone asked again, who was driving it, you loudly exclaimed, me, again, lying, correct?
Correct.
And then 11:22, when you said, that's what I'm saying, I was doing 45, that's my car, again, you were lying, correct?
Correct.
And you testified today.
Objection, Your Honor. Her estimation of how fast they were going wasn't a lot.
Your Honor, she didn't say we, she said I. That would imply control of the car. I was driving 45.
When she said I was driving 45, I'm not gonna allow that to be an objection. Just overruled.
And then just a minute ago, you said you had no problem lying to help someone avoid a criminal punishment, correct? So just a minute ago, when you were testifying, you said you lied to help Moses avoid criminal punishment. Is that correct?
Correct.
But you expect the jury to believe you're telling the truth here today.
Correct.
Further questions, Your Honor?
Redirect.
Thank you, Your Honor.
Kayla, when I asked you, do you regret trying to protect Moses that day, you said yes.
Yes.
So you do regret having lied to the police that day? And if you had to do it over again, you would not lie to the police, would you?
No.
Okay. And I am not certain. My recollection is not that you said I was driving, but that we were going 45. What was your intent in pointing out the speed limit at that time?
I don't recall.
Okay. You were just responding to the situation?
Yeah.
Okay. And just once more, the reason you were trying to protect Moses that day was because?
I didn't want him to go back.
You didn't want him to go first. Thank you. One more question.
Okay. Any questions from the jury? And while they write their questions, I have a question, because I just need to know, where were your shoes?
In the passenger seat.
Why were your shoes in the passenger seat?
That was in the passenger seat.
Where was your wallet?
In the middle, like in between the driver's seat and the passenger seat, it's like a middle console. And it was in there, in the middle console.
And then, was there an airbag that deployed in the car?
Yes, the dashboard on the passenger seat came out in front of me. The window to the right of me came out, and the back seat window came out on the right side.
Okay. Any questions from the jury? And do you recall if you said I was driving 45 or we were going 45? Do you recall?
I believe it was we were going 45.
Where were you on your way to?
He was driving me back to my house.
Did Moses ask you to lie for him?
Yes.
Did you feel threatened by Moses? Any other questions? Any cross-examination based on my or the jury's questions?
Just briefly, Your Honor, you claim that you were in the passenger seat. The most damage was to the front passenger side of the car, correct?
Correct.
And based on all the video you saw yesterday, there were 2 injured individuals and you did not seem injured at all. Would that be a fair assessment?
No,
That's not a fair assessment.
only one person. In the hospital.
Okay,
The
but
guy in the back seat, nobody else.
so you were in the portion of the car that was most seriously damaged in the accident,
Yes,
and you had no injuries.
I did.
You had injuries based on the video we saw yesterday?
Correct.
Were you seen by medics?
I was with the hospital. I don't. They checked me out.
No further questions, Your Honor.
Redirect.
So the only person who had documented injuries was the person in the back seat.
Correct.
And do you feel that the airbags protected you that day?
I do.
Thank you. No further questions.
Okay, I'm just clarification. So Moses didn't have any injuries?
No.
Okay. So the person in the backseat had injuries, not, and Moses was the driver?
Correct.
Okay.
I'm just gonna object, because she is not a medical expert, and maybe she is testifying.
You all asked, you all brought
I
the injuries
understand, but-
question, so the objection's overruled. You asked the question about the injuries, and she said the person in the back. Now they have to be clear to hear whose name it was.
I understand that, but I think it has to be taken within context of her perception of injuries. Because if you saw the video, which is already admitted into evidence, there are.
I've overruled the objection because you asked the question, you opened the door as to whether or not there was 2 people in the car injured. She said that's false. He asked a follow-up question and she explained the only person with injuries was the person in the back. You all brought up the injury question, so now you can't object to us fleshing it out so that the jury knows who was in the back versus who was in the front. So the objection's overruled. Any other questions? The jury has questions? Aside from a blood draw, what else were you checked out for at the hospital?
I don't recall what all they checked.
Answer so they can hear you.
I don't recall what all.
There's another question.
It was,
Okay, what injuries did you sustain?
nothing was figured out. I don't really.
Question? If you're writing a question, you can raise your hand so I know that you're writing a question. Okay. May this witness be excused?
Yes, Your Honor.
You can be excused. Any other witnesses from the defense? Mr. Lee, you calling other witnesses?
I'm sorry. No, Your Honor.
Okay. Rebuttal witness?
Your Honor, the people would call Penny or Sergeant Elton Penny, Sergeant Penny Elton. This would be a proposed 5.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do.
Thank you. You can have a seat. Since your other witness, if so, he needs to step out while she testifies.
Yep.
Can you state your first and last name and spell both?
Penny Elton, Penni,
Elton. Please proceed, counsel.
Good morning, Sergeant Elton. What do you do currently?
I'm currently assigned to staff services, which is in central records of the police department.
So you're a police officer.
Yes, I am. I'm a
Oh,
sergeant.
okay.
Yes.
How long have you been with the Lansing Police Department?
21 years,
How long have you been in your current position?
just under a year.
Okay. And what are the type of activities you do in your current position?
My current position in staff services is recruiting and dealing with our central records. However, for the 3 previous years, I was a sergeant of our quartermaster unit.
And what does being the sergeant of the quartermaster unit entail?
That means supervising and being responsible for all of the evidence from birth to destruction or dissemination.
And I'm going to show you what is marked as the people's proposed exhibit 4. Do you recognize this document?
May I? Yes, I recognize the type of document. I do not recall the specific incident, but I understand how it's written.
Okay, and is this a document created in the ordinary course of business?
In quartermaster, yes, sir.
And it's created contemporaneously?
I don't understand the words.
When these things happen, this document is created.
Yes.
Okay. The people move to admit people's exhibit number 4.
What is exhibit number 4?
It is a Lansing Police Department property evidence, I guess, tracking sheet.
No, we already did 5.
Chain of custody.
You already admitted
I think it
4.
should be 5, sorry.
Oh, I'm sorry.
Is that right, 5?
Oh, it's 5. I apologize, Your Honor.
Okay, it's. Okay, you said, she was telling me the exhibit number when you was telling me what it was.
It is the LPD's chain of custody document, Your Honor. I do have a copy for the court as well, if you'd like.
Thank you. Can you question though how this is generated?
How is this
I'm sorry?
document generated?
I'm unclear as to specifically which document we're talking.
It should be 5, not 4.
Thank you so much. Thank you.
Thank you. I'm sorry.
How is this document generated?
It's automatically generated. Every single piece of evidence is assigned a barcode. As soon as it is tagged in, the barcode is created. So every single time that evidence is touched, moved, checked in, checked out, then it is automatically logged in the system. We scan it, and that's how every line, say I scan, I create it, that's made by Penny Elton. I move it into the refrigerator by Penny Elton. Or if I give it, I sign it out to someone else, it says Penny Elton signed it out to someone else. So every single movement is documented in our system for every piece of evidence.
And Sergeant Elton, do you see your name in this on this document?
I do, twice.
Okay, and I'll direct you to the first entry, May 14th, 2021 at 6:53 in the morning. There's a documentation there that says cart. What does that mean?
That means I located it. All of our evidence, when it's tagged in, is tagged into a secure evidence room. They're either in lockers, or if the evidence needs to be refrigerated, it's in the refrigerator. As the sergeant or as a representative of our evidence unit, I would enter the evidence room every morning and take the evidence and put it on the cart. And we talked about every time we touch it or move it, that means I located the evidence in the refrigerator and I scanned it to the cart, which means I removed it from the evidence room and put it in the cart. That's what that documents.
Okay, and then we have an entry later, 5:14 at 8:12 a.m. that says fridge 4L. Could you describe that?
Absolutely. There is a time discrepancy. I got it at 6:53. At 8:12, I logged it into the fridge, which is behind in our security unit. Difference is it wasn't the only piece of unit that day, I guarantee it. So it takes time to process all of that evidence. But that means I secured it in the fridge, in our locked refrigerator behind our secure walls. Yeah, 8:12. Yeah.
Okay, and then The number up top, that incident number, what does that refer to?
The incident number refers to the report number assigned to the incident on the road. The original officer pulls that number.
And just to confirm, I'm going to show the witness People's Exhibit 2. Is that the same number?
It is.
And so that would confirm that that sample came from this incident and this withdrawal.
Correct.
Okay, and then I see an entry for 5/13 at 6:30 a.m. For Matthew Stevens for property and evidence submission. What does that mean?
That means we talk about, that's when Officer Stevens was logging the property into the evidence room. And that's initially when he enters all the information into the computer. And then that computer prints out a tag, and that tag is then affixed to the evidence, which would be the blood tag.
And then finally, on May 19th at 8:11 a.m., it has Olds George released. What does that mean?
And then may I also refer to the name that's signing it?
Yes, correct.
So 8/11 on the 19th, what that means, George Olds is our evidence technician, where our court officer, Ryan Hackenberg, is responsible. He picked, it looks like the blood, the blood sample was checked out. And what that means is Officer Hackenberg came up to Quartermaster, said he needed this evidence. George Olds came and removed it from the refrigerator where it was. It was actually scanned and signed out / released to Officer Hackenberg. At that point in time, what release means is out of our evidence. And then it was in Officer Hackenberg's custody at that time. And I'm sorry, may I? It's also under there, it says it was also, he was taken to the lab. That's what he was taken. You had a motion to admit 5.
Motion to admit 5, Your Honor.
Any objection?
No objection, Your Honor.
5 is admitted.
And then I would make a motion to publish.
You can publish. Did you need to cross, or you want to cross-examine this witness, or you have more questions for her? You're going to cross-examine this witness? She can take my copy if she needs. Thank you, Your Honor.
Sergeant Ellen?
Elton.
Elton, I'm so
Like Elton
sorry.
John.
Like Elton John, all right. Sergeant Elton. So you were working at the quartermaster office, and your job was to take evidence from the police evidence room and put it into your storage facilities and or move it out of your storage facilities and transfer it to a police office for some other reason.
Yes.
Okay. And who conducts the checks on your storage facilities to make sure that the temperatures are right and all like that?
It's done several times throughout the day. And especially there's, we actually have a special refrigerator that sets off an alarm if the temperature goes above or below the designated temperature. So it's constantly being monitored.
Okay. And then you also track how long it's been out of the refrigerator. So every time you scan it, it's time stamped?
Yes.
Okay. Thank you.
You redirect.
None, Your Honor.
Questions from the jury? None? Okay, thank you, Sergeant Elton. Thank you. Let's see. I don't think we need to call Mr. Olds based on her testimony, but we're still gonna call Hackenberg or recall Hackenberg.
Your Honor, it's our intention to recall Officer Hackenberg. He is in the middle of an official exam at the Michigan State Police at this moment, and it's not available until approximately 2 p.m.
I can't hold the jury over here from 10 till 2, waiting for testimony. to excuse the jury.
Here.
Hey, what's your name?
Imani Mitchell.
Okay, what's already on that docket sheet? No, this is somebody. Huh? Oh, that's from yesterday. Sounds good. Amani Mitchell.
Yes, ma'am.
We're in the middle of a jury trial, so I'm gonna reset your matter, okay?
Okay.
14th. May 14th at 10.
10 a.m. Yes, ma'am.
Yes, 10 a.m. Okay, and then you do have counsel. Your attorney will be in contact with you. If you don't hear from your attorney within the next 7 days, you call the public defender's office, okay? Maybe they don't have an accurate number, okay? Okay, thank you. I see King's iPhone. What's your name?
I'm sorry, I forgot to change that, man. Bernard Lewis Dean.
Okay, I see him scheduled. I'm in the middle of a jury trial, so I do have to reset your matter, okay?
Yes, ma'am.
It'll be May 14th at 10 a.m.
Yes, ma'am.
Your attorney will be in contact with you. Before then, if you don't hear from your attorney, you call the public defender's office, okay?
Yes, ma'am. Thank you.
Thank you.
Yep.
God bless
Have a
you.
blessed day.
There, oh, they can come in. Sir, you can remove your hat, please. What's your name? For the record, in the matter of the people of the state of Michigan versus Tyler Bunkley, file number 20-02272. Mr. Bunkley. Today was the date set for show cause because you didn't pay your fines and costs. It looks like you originally had a balance of $625. You saw the magistrate on June 16th. You said that you would pay $50 a month beginning July 7th. You then got a extension from Judge Ward until December 15th. And now it's April. Are you employed, sir?
Yes,
Okay, why aren't you making any payments?
I made payment today and yesterday,
How much did you pay
45.
in total?
Yeah.
When are you gonna make your next payment?
As soon as I get paid, like 3 weeks.
So you're gonna pay $45 a month?
Well, the agreement was 20 a month.
It said 50 a month in here.
I made the agreement with that lady on the hall, 20 a month.
I don't know who the lady down there is, and
It was in the corner.
I get that. I have in my handwriting that you were gonna pay $50 a month, and then the magistrate a month later put the same thing, $50 a month. I don't see anything in this file that say you had an agreement for $20 a month. That's not a problem. You can make a payment of $20 a month.
Yes.
And when are you gonna pay next month? You said in 3 weeks?
Yes.
I'll note here that you'll make a payment of $20 per month, no less than the 30th of the month, okay?
Yes, ma'am.
You're all set. Thank you. Someone else had a show cause? What's your name?
Carla Rose.
On the record in the matter, the people of the state of Michigan versus Kyler Welch, file number is 22-03536. And Mr. Welch, it said you were supposed to pay a fine of $300 by November 21st.
Yeah.
What happened?
During the month of November, I was dealing with some mental issues. I was in the hospital for the time of November 30th to January 12th, I believe.
Okay, so when are you gonna make a payment on this?
I might make a payment in the next month.
How much?
$20.
Are you employed?
Not currently.
What day next month are you gonna make a payment?
I can make it on the 5th.
Okay, I'll note here, you'll make a payment of $20 the 5th of each month, beginning May 5th, okay? You're all set. Mr. Raleigh, did you have a case?
If one of was expected to appear on Zoom, it's Bernard Lewis.
Bernard Lewis, oh, we reset him.
Okay.
Yep. May 14th at 10.
Thank you.
Okay. Okay, Mr. Lee, you can come back up. We're gonna do these. You can kick him out of your slot. I'm resetting any state cases. I gotta get this jury out of here as soon as possible. Well, you can be seated. I'm just going over, make sure I have the ones that were requested. There was a request for 3.4, but I don't believe that that's necessary here. So I'm not gonna add that. And 3.3 took out, 3.5 was in this. There's a request for 3.5A summary of evidence. Why is that being requested?
Was that a request of ours or of the defense's? Yeah.
That's a request of the prosecution. Just because there's a lot of evidence, so they have videos and they may, can only imagine, I've never seen this many questions from a jury. So
Right.
I'm sure that they're gonna wanna see those videos or have something, so. I'm inclined not to add, I've never added 3.5A, so I'm not inclined not to add it unless there was a particular reason why you all wanted a summary of the evidence.
Sure, I guess the city will address it in closing.
Very good. Okay, so we won't add 3.5A. 3.6 is in 3. Eight needs to be added. Which is less serious crime. Let's see. Yeah, miss the people on the further waiting room. Let's keep on the waiting room.
Is my name short?
.1 defendant's statement as evidence against defendant. We think that's necessary.
The city would suggest that it does, Your Honor, as she did indicate several statements about admitting to lying to the police. and other factors that
Well, I'm not talking about her testimony. I'm talking about the statements. Was there a statement? Did another witness use a statement? Yeah, I'm not talking about her testimony.
I think only to the extent that the video includes her out of court statements. Your
The video was admitted as evidence. I'm just wondering if anybody else made a statement that was an out of court statement, because obviously the statement she made on the video would come in. I'll put it in there, but just in case there was. Let's see. Right, 3.1. Why does it always do this? Point five, let's see. I don't believe the city impeached anyone.
No, I don't believe so either, Your Honor.
The defense made an impeachment, I believe, during Officer Stevens.
I don't think that was based on a prior statement.
That was just, it was based on how the accident occurred.
Sure. With Stevens.
So I don't keep that one away. Mr. Lee, you made a request yesterday. I think it was for a witness not being present.
That is correct.
Your Honor, I know the city briefly objected yesterday, but we do have some additional information we would like to present on the issue of that question.
Just one minute. I don't think the facts, just an exhibit. We need 4.7 stipulation.
I believe the only stipulation was to the video, not to a fact.
I'll delete that slide for today. Motive 4.9.
I mean, Your Honor, I believe the defense theory of the case is essentially that.
So you both requested, I'm putting it in.
Oh, okay.
Yeah. I was just thinking of that. I think 5.2 is already in there. There's something with this up in this. Which jury instruction were you requesting?
Requesting the jury instruction that if the witness didn't show up, that it would be assumed that his testimony would be beneficial to the defendant. And
Okay, 5.12. Witness's appearance was responsibility of prosecution. That's one you're requesting?
Yes.
Okay, Mr. Staples.
Your Honor, the statutory basis for that is MCL 760.40A. Subsection 5 of that statute reads that the prosecuting attorney or investigative law enforcement agency shall provide to the defendant or defense counsel on request reasonable assistance, including investigative assistance, as may be necessary to locate and serve process upon a witness. In this case, process was served on Officer Ranson. It additionally says that the request for assistance shall be made in writing by defendant or defense counsel not less than 10 days before the trial of the case, or at such other time as the court directs. Again, this request was made to our office Wednesday of last week, so approximately 2 days before trial. So I would argue that this instruction is inapplicable per the MCL that creates this duty on the prosecutor's office. And I have a copy for that if the court would like to. Yeah.
Do you want to respond?
Your Honor, the prosecutor specifically called and got the participation of every single person involved in the investigation, including lab technicians and so forth. They called at the last minute. The only person that they couldn't get to attend today, this trial, was Officer Remsen. And coincidentally, Officer Remsen's testimony and video would have been very helpful, exculpatory to our case.
Response, Your Honor.
Yes.
I believe it was made clear on the record yesterday that the only reason Officer Remsen was not able to appear is because he has had shoulder surgery and is at this point incommunicado. We have made strenuous efforts to secure him. I made significant efforts even last night after court to see if we could get a hold of him, to see if he could appear via Zoom. It's just unclear if he's currently in the hospital, if he's heavily medicated. I mean, we just literally cannot track him down at the moment, but strenuous efforts were made on the part of the prosecution to do so. I will say there is also case law, People v. Eccles, that states a prosecutor who fails, and I'm sorry, that site is 260 Mishap 379. A prosecutor who fails to produce an endorsed witness may show that the witness could not be produced despite the exercise of due diligence. I would say in this case, Your Honor, given the very short time frame presented and the extensive amount of work the city did to try to produce this evidence, this would fall under that standard.
Your Honor, the defense called Officer Remsen, subpoenaed him at the first trial. This was originally scheduled for trial. It should have been no secret to anybody that we were going to request Officer Remsen and or that he, as well as every other officer on the list, would be called. They got everybody else. Everybody they thought would be favorable to their case was here. The only person that might not be favorable to their case is not here.
So you previously submitted a subpoena for Officer Jack?
I'm sorry?
You said you subpoenaed him for the first time?
Yes.
When was that?
That was in 2023.
Your Honor, the last trial date I show in our system, that was an actual trial date, would have been July 11th of 2023 prior to this point. So what is that? Eight some odd months ago.
That the matter was set for trial. My records show.
I believe there was a lengthy delay, Your Honor, because there was some.
Yeah, there was a lengthy delay. I do see that May 9th, we set it for trial, July 11th. And you submitted your request then, is what you're saying?
Yes, at that time, he was one of the people that were subpoenaed. That is correct.
Okay.
Can you? The city has no record of receipt of that subpoena. Can Mr. V clarify as to who he sent that to? And when?
Hold up.
And I will say, in addition, Your Honor, this trial date seems to have been set at the beginning of April, and no request was received by our office until last Wednesday.
Well, I'm noting the dates that we both sent your information. It both was on Wednesday.
Our subpoenas were sent far before Wednesday, Your Honor.
I'm talking about when did you exchange your witness list?
The witness lists were exchanged sometime late in the week, but when I brought up the point of Mr. Remsen not being a complaining witness, the court indicated that he was included in several other documents which were turned over in discovery to the defense
He was
some
included.
time ago.
He was included. He's included on all the OWI worksheets. He was included on the video. That was, I mean, his statements obviously could have been heard. And it didn't give the defense an opportunity to question or cross-examine that, although the jury's gonna hear those statements because there's a stipulated video coming in with the statements there. And I recognize that there was a date that was pushed back. If he's saying that he provided notice, at least in the first court date, that he wants this witness there. You all didn't exchange witness lists again, I don't believe, until the 26th. that accurate?
That's it.
That would be the same day that he now is reminding you, I wanted Remsen Jack here.
Yes, the original subpoena was served on to LPD via the email process. It was dated Tuesday, March 28th. I'm sorry, that's the date he was still here. Proof was signed by Sarah Donnelly on March 17th, 11 days before that trip.
Your Honor, the city will then continue its objection as the statute requires notice to the prosecutor's office, not to the Lansing Police Department. So not only was it untimely in the most recent one, the prior attempt to serve that subpoena was not properly noticed to our office.
Well, he's saying that there was a subpoena or a notice sent to LPD. And you didn't get a response from that?
I cannot speak to it because I didn't serve it, but my associate Sarah Donnelly
Okay.
did.
Ms. Donnelly's in the courtroom. Can you place your appearance on the record?
Your Honor, Assistant Public Defender Sarah Donnelly.
Okay, you submitted a subpoena for Remsen Jack on back in March on this trial?
Your Honor, I'm trying to remember, obviously, like I said, this, the original jury trial on this was set for July 11th, 2023. I do recall that a proper subpoena was served on Remsen at that time by our investigator. I can't be 100% sure if it was also served on the city. I'm trying.
You're talking about March 2023?
No, I believe I filed.
There was
No,
a
let me
trial.
see here.
To be,
Go ahead.
I was just gonna say, to be clear, Your Honor, there was a trial date also scheduled in March of 2023.
Okay, so
Yes, so in March of 2023, I think what the notes indicate is that we filed it the way we normally filed it. So we send our notice off to the LPD and they notify whoever they need to notify. Later, in the second, when it was rescheduled, we subpoenaed him directly, handed him the subpoena. That, I believe that's what we've said so far.
Okay, no, that's no problem.
Yeah.
The law that the city is using in support of their objections is entitled List of Witnesses, Duty to Disclose Names. And so it says that duty should have been done 10 days prior or at such time that the court directs. I don't require you all to submit that information 10 days prior. You didn't activate your duty, at least in this one, until the same date that they responded back. You disclose your witness list on the 26th. The 26th, they say, no, we want Remsen Jack. And if I look at the history of this case, they've notified the city more than one time, whether it was through a subpoena or previous interaction that they wanted Remsen Jack. I indicated in my previous ruling on this that Remsen Jack was obviously seen in the videos, and at the time we didn't know that, but his name is seen on the OWI worksheet. His name comes up multiple times on this, and I'm inclined to believe that the city had reason to know that he would be a witness that the defense wanted to have here, and that the defense is saying we notify them that we wanted him here. We know that it's not your fault that he couldn't be here. There's no way you can stop someone from being out on medical leave. But that doesn't negate the fact that there's a jury instruction that is available when there's a request to produce a witness and the witness did not appear. And in that case, it's Officer Remsen Jack. I'm going to overrule the objection because I do not require you to submit or exchange a notice of your witnesses 10 days prior. You've never exchanged them 10 days prior. Sometimes we got to track you all down on the Friday before for your witness list in your jury instructions. You all exchange them both on the same date, and it'd be one thing if maybe the city said, no, we sent ours 10 days prior. If you had told me you sent yours 10 days prior and they waited till Wednesday, my ruling would be different, but you didn't send yours until Wednesday, and that's when they responded. So for that reason, I'm going to grant their request to include the jury instruction as it relates to the prosecutor's failure to produce a witness. So that's 5.12 will be added. Oh. Try to print something, I don't know if it's going through. I have to email it to you. I believe, Winston Jack is a sergeant, is that correct?
Correct, Your Honor.
Okay, let me have this sent to you for you to review, and I will figure out what's going on with my printer. You can forward those to them. Why is this not printing? You can do that one, trash. I just was testing it. Okay, I see a Jacarla McLean. Can you unmute your device, Ms. McLean? Can you hear us? I can't hear you. And Sergio Archer?
Yes, ma'am.
Okay, I'm in the middle of a jury trial, so I have to reset your matter, okay?
Okay.
May 14th at 10 a.m.
Okay.
You're all set for today. Ms. McLean, I don't know if you can hear me. I'm doing the same. She, no, 10, well, 10:30. She said she can hear me. She can? She can't. She's in the chat. Sure, why not? I guess they don't like that one, or just things into the jury room back there. You can message her in the court date. Lindsay Anderson?
Yes, ma'am. I'm actually here as a foster care worker for a case that was supposed to be heard at 10:30.
Case?
For Smith, Marion, and Diamond Wiggins.
Okay. I'm in the middle of a trial, so this is gonna be reset.
Okay, can I get that reset?
Are they here? Who is this? Wiggins and Smith are here? Are they here? My age is here.
We can tell you they are not.
They're not here? Yeah. Gotcha. Okay, they're not here.
Okay.
So I can't give you a new date at this time.
All right, thank you.
You're welcome. No. Okay, did you get the composites?
Did Your Honor?
Okay, and then this is the proposed jury. I just redid it. You can let me know if more changes. You can show us to
Your Honor, the people's only note would be that guilty of has a blank and then the lesser are spelled out. Could that just not be guilty of operating while intoxicated, high body alcohol count? That just seems a little confusing.
guilty of, it should be.
Instead of just that.
Gotcha.
Blank. And then that's also on slide 39.
Oh, I put language in the jury instruction.
Right, since the other ones are, yeah. Yes, I agree.
That's what slide?
Yes, slide 39, Your Honor.
Okay. That's to be changed. Any other changes on the deposits?
Just for your, so that you're aware, Your Honor, there's a couple slides, 23 and 31 that have the little click to add title boxes. I don't know if you want to delete those or not. Just wanted to bring it to your attention.
Thank you. Actually was going to remove 23 just because it's already, I added 24 and 25 instead.
Okay.
Which gives it their lesser included charges. Let's see. So I'll delete that one. And what was the other one?
31. Yes, 31.
31 is actually hidden. Slide 31?
Yeah.
3.12?
No, it doesn't. It just says click to, oh, it's gonna have.
I deleted something. Wait a
Yeah,
minute.
so I think it'd be probably maybe 30 now, because you deleted one, or 32.
Just says, however, although you should try to reach an agreement, it's an instruction for them to try to find consensus.
Oh, you're talking about the top thing where it says click that title?
Yeah.
Yeah, yeah.
It doesn't show up actually on the slideshow.
Oh,
I don't
okay.
know why it does
I
that.
just wanted to make.
Yeah,
Your Honor.
it shows up on my thing, but it doesn't show up on the slideshow. Let me see. Okay, I need about 5 minutes. I get my restroom and then. China, is you here, Mr. Lee? Wait, who is that? Oh, China Roberts. Are we just setting that for final pre-trial probably?
I guess, Your Honor.
Okay.
It wasn't on for extension.
On the record, in the matter of the people of the state of Michigan versus China Roberts, file number 23-03624, counsel appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of China Roberts.
Okay, Ms. Roberts, today is the date set for a pre-trial on an assault and battery. How are we proceeding?
Your Honor, at this time, we would like to set the matter for a final pre-trial and trial.
Final pre-trial, June 18th at 8. Trial July 9th. Final pre-trial, June 18th, 8 a.m. in person at the court, and then the jury trial. That would be July 9th at 8 a.m. Okay? Do you have any questions today? Additional matters for the record today.
Nothing further. Thank you.
Nothing to the defense, thank you.
Right, good. I'll be yours back. Do you have all the exhibits?
I'm sorry, what was your question, Your Honor?
I just want you to make sure you keep all the exhibits. And then if they want them, when they deliberate, they'll request them from us. I don't know if I need to do something with that paper. I'm just gonna read that. Send you the instructions you can. I send you the instructions you can put the picture. Okay, looks like Marion Smith is in custody. So we'll set his. Okay. Okay, back on the record in the matter of the people of the Lansing versus Kayla Walker. Are we ready to bring the jury back?
Rolling through the instructions, Your Honor, they seem good. Yes, I'm fine.
No problem. We'll bring the jury in and then you'll have time to do that while they do closing arguments and final instructions.
All right, for the jury.
Okay, thank you for your patience. You can be seated. And we have some evidence that needs to be published.
Correct, Your Honor. Your Honor, at this point, the people would move to publish to the jury plaintiff's proposed exhibit 3, which is the Michigan State Police Laboratory file.
No objection.
Yep, it's been admitted, so it's to be published. You can proceed to closing statements.
Ladies and gentlemen of the jury, the record has shown that on the afternoon of May 13th, 2021, the defendant got behind the wheel, drove a car on a public street in Lansing, Michigan with a blood alcohol content of nearly 4 times the legal limit. You've just heard over the course of yesterday and today the evidence that proves that. I'd like to take a minute to walk through that with you and kind of break that down a little bit. I'd like to refresh your memory on the 3 elements that I have to prove to you here today. Those 3 elements are that the defendant was driving on a public road in the city of Lansing with a blood alcohol content of over 0.17. I'll start with element 2, or the driving on the public road element, because I think we can all agree on that one. Officer Pung told you that her and Officer Simmons were getting gasoline at a gas station at the corner of MLK and Kavanaugh when a car accident happened. You saw the aftermath of that accident on video. You saw defendant's car broken down in on the right-hand lane of MLK, Martin Luther King Jr. Boulevard, which is a street open to the public within the city of Lansing. Next, the defendant was intoxicated. You saw plenty of examples of the defendant's behavior on Officer Pung's body camera. Officer Pung testified to you that she believed that the defendant was intoxicated based on her experience as a Lansing police officer. You saw that the defendant was able to follow instructions and perform even the most basic parts of the standardized field sobriety test. You heard defendant's slurred and incoherent loud speech. And then finally today, you heard defendant admit on the stand that she was drunk that day. Additionally, you heard testimony from MSP lab tech Brianna Welch and toxicologist Jordan Geiger about exactly how they go and test that blood that was removed from the defendant that day. You heard lengthy testimony about the process, the chain of custody that blood went through when it went from defendant's arm to that MSP lab. Those test results are now in evidence. They're exhibit 3 right there in front of you. And they show that the defendant's blood alcohol content on that day was 0.314. Now I'd just like to take a second and walk through with you that number a little bit, just by kind of using my body and the space in this courtroom. So if we say I'm here and this is a 0, this could be a 0.08. 0.08 is the legal limit. If you go over a 0.08, that's intoxicated. If I take one more big step, we're at 0.17. That's the standard I have to prove to you to prove that she had a blood alcohol content of 0.17 or greater to meet the charge of operating with a high bodily alcohol content. That's just over 2 times the legal limit. One more step, and we're at approximately 0.24, which would be 3 times the legal limit, right? 8 times 3, 0.24. Then we take one more step, and we get to where the defendant's blood alcohol content actually was on that day, 0.314. That's almost 4 times the legal limit. Based on all of that evidence presented to you, I believe there is no doubt that the defendant was intoxicated on the day in question. Finally, and you've heard the most about, defendant was driving the vehicle. I want to bring you back to when we were talking during voir dire, and I talked to you all about circumstantial evidence. And I talked to you about how if you see me come in and my hair's wet, and my coat's wet, I say to you it's raining, and maybe when you were driving in that morning, you see some storm clouds on the horizon. That would all lead you to be able to infer that it is in fact raining. In this case, we have an analogous set of circumstances. Let's take a minute to add up what you all heard and saw. You heard the testimony of now Detective Jennifer Pung, who was a long tenured Lansing police officer in the Lansing Police Department. She has a lot of experience. And you heard that she conducted a very thorough and lengthy investigation. And you saw on the video that was played in front of you that her conclusions changed, right? She had a theory, she tested it, she had other theories, and she finally came to the conclusion that defendant was the driver. How did she come to that conclusion? She observed several things, right? First, and right off the bat, the defendant told her multiple times that she was driving the vehicle. She saw the defendant with the keys to the vehicle in her hand for almost the entire time, until, as you saw in that video, towards the very end, her mom came and snatched them out of her hand. She saw the defendant, you saw it on body cam, get right into the driver's seat of the vehicle, which just so happened to be where her driver's license and her documents were located. That she fit right in that driver's seat. Additionally, none of the other individuals you saw in that video ever claimed to have been the one driving the car. In fact, some of them stated that defendant was driving the car. When you add it all up, just like we talked about before, it leads to the inevitable conclusion that defendant was the one driving this vehicle. Now, we've just taken a second and walked through all the evidence. And I know that just a second ago, defendant said she wasn't driving. But defendant, at the same time, when she was giving that testimony, admitted to lying to the police about this very incident. Now, ladies and gentlemen of the jury, you can weigh the testimony of the individuals you've heard today. And I ask you, when you're doing that, to take into consideration that the defendant has a motivation to lie. She's being charged with a crime. I believe that it is clear from the evidence presented to you that the defendant was the one driving that day. On a road, Martin Luther King Jr. Boulevard, which is open to the public and located in the city of Lansing, Michigan, with a blood alcohol content above 0.17, as we just talked about a while ago, 0.31, far above 0.17. And I told you in my opening that it was my responsibility to prove those things to you beyond a reasonable doubt. Therefore, I ask you to find the defendant, Kayla Walker, guilty of the offense of operating a vehicle with a high body alcohol content. Thank you.
Sorry.
Thank you to all of you as well. It's been a long, long trial, and this is probably the last time we'll speak, so I want to make sure you hear me say thanks. I appreciate you guys being here. The prosecution is relying very heavily on circumstantial evidence. I told you at the beginning of this, I have a lot of respect for the police. Police have a very tough job. And you saw in the video, this was an accident scene that was very chaotic. The officer testified, hey, normally we wouldn't let people congregate and talk and work things out amongst themselves. We would normally separate them, but I didn't have enough bodies to do that. So she really didn't have control of the scene, and there was a lot of conferring that was allowed to go on. The defense will talk, or I'm sorry, the prosecution will talk to you about, well, she admitted it. Well, she also denied it. She denied it as many times, if not more, than she ever admitted, okay? So we have conflicting testimony. So they said, okay, well, what do we do next? Let's go to some physical evidence, see if there's some circumstantial evidence to help us figure out what happened. And they point to several things. I'm going to go through a couple of them specifically, but I want to just submit this to you. The burden of proof is beyond reasonable doubt. If you tell me, hey, this happened and this is what it means, and I say, well, that's what happened, but maybe it means this, and it's an alternative reasonable explanation, that means there's two alternative reasonable explanations. That's not beyond reasonable doubt. Oh, she had the keys in her hand. Her car, her mom's car. She knows what's happening next. Mom's coming. She better have them keys in her hand, right? Oh, well, she got in the driver's seat to get her wallet. It's her car, out of habit. If you ask me to go to get my wallet out of my car, I'm going to get in the driver's seat to get my wallet because it's my car and that's where I go. You know, her wallet was in the center console, very easy to reach from there. Plus, the passenger side had a lot of damage, right? There was testimony that the airbag went off on the dashboard side and the side airbag went off. So if you tried to get in through the passenger side, you'd be fighting through airbags to try to get to your wallet. So that doesn't mean anything. I think there's a paradigm problem here, right? Once you decide somebody's guilty, then everything you see is evidence of their guilt, right? So when the officer got up here on the stand and couldn't even tell us accurately how the accident happened, the city attorney immediately jumped on his false explanation and said, yeah, and that's further evidence that she was intoxicated, right? He wasn't even giving you the right facts. But once you get into that mindset, that's how everything is seen. And I think that's all that happened here. You know, it's a tough job. They just didn't get it right. So shoes. He wasn't wearing any shoes. Who drives with no shoes? I don't know. There was some talk about the seats. You heard the officer went back and forth on this seat thing because she said she couldn't see the passenger seat clearly. You guys have the videos. If you want to look at it, you can take a look at it for yourself. My submission is not so much who could drive with the driver's seat in that position. My submission is who could sit in that passenger seat with the passenger seat in that position. It wouldn't be a tall person, I can tell you that much. Okay. So this circumstantial physical evidence that they went to try to figure out what was going on could be read a lot of different ways. That's called reasonable doubt. There is no smoking gun here. There is nothing here that says definitively, yeah, she was driving. And all their explanations have very plausible, reasonable, and in fact, factual alternative explanations. So we can't just prosecute somebody because we want to prosecute somebody, right? You heard Kayla Walker get on the stand and admit three things. Let somebody drive her mom's car. That somebody was somebody she loved. And that somebody was on federal parole. And when she was faced with what to do on that day, in her condition, she decided to try to protect him as much as she could. Bad choice. Bad choice. I asked her, does she regret it? Yeah, she regrets it. You know, she would do things differently today. We talked a little bit in the beginning when you're in your 20s, sometimes your life changes, right? She was 24 then, she's 29 now. A lot of changes have taken place in her life. She would do things very different. Take you back to the very first time she was asked who was driving the car. Spontaneously, out of nowhere, the officer asked who was driving the car. She pointed right at Moses. That was her first initial instinctive response into the truth. You heard the prosecution say that criminals lie about committing crime, and they're right. They do. The person on federal parole lied very well. all the way through and was excused, summarily excused. Officer Pung walks up to her mom and says, well, if it wasn't her, who could it be? And ironically, the person standing right behind mom is Moses. Well, that's who it could be. And you knew that because you already said the other guy was a passenger in the back. And even though Officer Pung says, well, at the end, she thanked me. She thanked me. You watch that video, her and Officer Pung were not vibing. They just weren't. And there was another officer there whose testimony you didn't get here and whose video you didn't get to see. You're going to get an instruction on that. Went a little bit differently with that one. Okay, so just understand these are human beings and emotions are at play, and they feel a responsibility to hold somebody accountable, right? She did the best she could do. She just got it wrong that day, and maybe not even her fault. Maybe not even her fault. But here's the thing: two wrongs don't make a right. She was wrong to have lied to the police that day, but it would be wrong to convict her of a crime she didn't commit. And if we do that, that's two wrongs. Two wrongs don't make a right. Bring back a verdict of not. Thanks.
Ladies and gentlemen of the jury, I have just a brief rebuttal for you. The defense set out each one of those little pieces for you and explained, right? Well, this little piece might be wrong for this reason. This little piece might be wrong for this reason. That's not what we're talking about. As we talked about with circumstantial evidence and the rain, right? It's not just that my hair is wet, right? My hair could be wet for a number of reasons. It's not just that my coat's wet. It could be wet for a number of reasons. There could be storm clouds for a number of reasons. It's what those things, when you put them together, make you believe. It's what that evidence as a combination, as a whole, leads to. Each one of those things are just a part. And sure, any part could have an explanation, but when taken together as a totality of all the things that were going on, they lead to the conclusion that the defendant was the one driving. Now, the defense has given you a boogeyman, told you all about this Moses. Moses isn't here. Moses didn't testify. We don't know anything about Moses other than that he was on a tether and that he was on the ground. They've given you a boogeyman. A boogeyman's a place in the shoes of the defendant. I'm asking you to focus on the evidence that you have that relates to the defendant. And finally, I would say that the defense, when they came up here, said that the defendant testified to 3 things today. In actuality, she testified to at least 5. The 2 that he left out is that she testified she was drunk that day. And she testified that she lied to the police several times during the course of that investigation. Thank you. Have a good day.
Okay, ladies and gentlemen, you can turn your attention to the screen one last time. I have some composite jury instructions. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true verdict, a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instruction about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with the crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, ruling, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based solely on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The elements of the crime: operating while intoxicated, high bodily alcohol content. The defendant is charged with the crime of operating a motor vehicle with a high bodily alcohol content. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. To operate means to drive or to have actual physical control of the vehicle. Second, that the defendant operated the vehicle on a highway or other place open to the public or generally accessible to motor vehicles, including any designated parking areas. Third, that the defendant operated the vehicle with a bodily alcohol level of 0.17 grams or more per 100 milliliters of blood to 10 liters of breath, 67 milliliters of urine. You may also consider a less serious charge of operating a motor vehicle while intoxicated. The prosecutor would need to prove that the defendant first had an unlawful bodily alcohol level, and while under the influence of alcohol, that the defendant first operated the motor vehicle. To operate again means to drive or to have actual physical control of the vehicle. Second, that the defendant operated the vehicle on a highway or other place open to the public or generally accessible to the motor vehicles, including any designated parking areas. Third, that the defendant was intoxicated. That is, that the defendant operated the vehicle with a bodily alcohol level of 0.08 grams or more per 100 milliliters of blood to 10 liters of breath, 67 milliliters of urine. And also that the defendant operated the vehicle while under the influence of alcohol. Under the influence of alcohol means that because of the drinking of alcohol, the defendant's ability to operate a motor vehicle in a normal manner was substantially lessened. To be under the influence, a person does not have to be falling down or hardly able to stand up. On the other hand, just because a person has drunk alcohol or smells of alcohol does not prove by itself that the person is under the influence of alcohol. The test is whether, because the drinking of alcohol, the defendant's mental or physical condition was significantly affected, and the defendant was no longer able to operate a vehicle in a normal manner. You may also consider the less serious charge of operating a motor vehicle while visibly impaired. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Again, to operate means to drive or to have actual physical control of the vehicle. Second, that the defendant operated the vehicle on a highway or other place open to the public or generally accessible to motor vehicles, including any designated parking areas. Third, that due to the drinking of alcohol, that the defendant drove with less ability than would an ordinary careful driver. The defendant's ability to drive must have been lessened to the point that it would have been noticed by another person. If the defendant's ability to drive that must have been visibly lessened, it is the defendant's ability to drive that must have been visibly lessened, not the defendant's manner of driving, though evidence of the defendant's manner of driving may be considered as evidence of the defendant's ability to drive. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about May 13, 2021, within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement, express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about a case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and a full copy of the instructions. If you want to look at any of the reference documents or the exhibits, including the video that have been admitted, you just ask for them. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. This is a sample of the verdict form, which includes the lesser included charge. So you can see the name of the defendant, count 1, which is operating while intoxicated, high bodily alcohol content 0.17 or more. You can return a verdict of not guilty, or guilty of operating while intoxicated, high bodily content 0.17 or more, or you can select one of the guilty of one of the lesser offenses, operating while intoxicated or operating while visibly impaired. Defendant's statement as evidence against the defendant. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. A prior inconsistent statement that was used to impeach a witness. You have heard evidence that before the trial, a witness, in this case, it was Officer Stevens, made a statement that may be inconsistent with his testimony here in court. You may consider an inconsistent statement made before the trial to help you decide, only to help you decide how believable the witness testimony was when testifying here in court. If the earlier test or statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. Motive. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He or she only has to show that the defendant actually committed the crime and that she meant to do so. You should decide this case based, you should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Police witness. You have heard testimony from a witness who is a police officer or witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Prosecutor's failure to produce a witness. A Sergeant Remsen Jack is a missing witness whose appearance was the responsibility of the prosecution. You may infer that this witness's testimony would have been unfavorable to the prosecution's case. That concludes our instructions. You'll get a list of those instructions. You should get that last exhibit, and we'll keep those until they request to view any of the exhibits, and then we'll get them to them. And then one of you do not have to stick around because you were the alternate. So I have a number representing each juror in this lovely cup, and we'll draw one name, or number, I should say. Anything else to me? Juror number 3, thank you for your service. You may be excused. Don't smile so big.
Thank
No? Still the alternates. Anything could happen. Okay, the remaining of you will be free to go and deliberate. Don't forget to first choose a 4-person. It is about 12 o'clock, but I want you to start engaging in some conversations before we give you a lunch break. And then if you don't have lunch or have a verdict within an hour, then I'll release you for lunch. And then you can come back. All rise for the jury. I sure do. You step right there. Let me swear him in. Raise your right hand. Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made from them or to them, orally or otherwise, until the time that they have rendered a verdict? So help you God. I do. Thank you. Okay. Be seated. Okay, my understanding is that you have a verdict?
Yes.
Okay, who was your fourth person? Okay, can you read the verdict?
The jury defines defendant Kayla Walker not guilty.
What the jury polled? Okay, juror number one, is that your true and accurate verdict?
Yes.
Number two, is that your true and accurate verdict?
Yes.
Number three, is that your true and accurate verdict?
Yes.
Number four, is that your true and accurate verdict?
Yes.
Number five, is that your true and accurate verdict?
Yes.
And you would be number seven, is that your true and accurate verdict?
Yes.
Thank you. I want to thank you all for your service over this course of these 2 days. It's not typical that we have 2-day trials in district court. We've had a lot of issues with trying to get accommodation, so it could be warm. There's not a lot of space here, but you all were patient with us as we navigated through those things. You all were very attentive. I was indicating I have not seen this many questions in one jury trial, but it was a lot of evidence that you guys had to pour over and listen to over the course of 2 days. And the justice system is crippled without people coming in and being participants as jurors. So I want to thank you for your service. You are free to stay back if you'd like to speak with either of the attorneys. You don't have to. You're free to go after you meet or talk to our administration so that you can get your day's pay for today. Thank you again for your service. All right. You can be excused. You can be excused, and can you pass me the verdict form on your way out? Thank you.
Okay.
Thank you. Acquittal by way of jury will be entered. You'll get a copy of that in just a moment. Any additional matters for the record? Actually, there was, because you can get your exhibits. There was a motion that I took under advisement. Obviously, that motion is null and void. Any additional matters for the record? Right here.